Okay. Well, first thing that I want to ask you to do is tell us what is your job title and explain what you do, what your role is.
Okay. Well, my official title is Regional Attorney for the Texas Department of Family and Protective Services. And what that title includes is not only do I represent the department in cases in Hill County where we're pursuing termination or the appointment as managing conservator of children who are in care, but I also work with other county attorneys in different counties throughout what we call Region 7 and help them with their cases if they have a conflict. And so right now I handle cases in about 5 or 6 counties, but my larger area is up to, I think, 20 counties. So I have quite a bit of responsibility, but Hill County is my only direct rep, is what we call it, where I actually represent CPS on all of their cases in Hill County.
All right, excellent. So you are actually an employee of the state rather than the county. Is that right?
Right. So I work for the department, which is a state agency. So yes, I work for the state of Texas.
Okay. I know in some other counties, they have county attorneys that do CPS cases. Is that the only, that your only client is CPS or DFPS?
Right. So I don't represent any other agency. I don't represent parents. I don't represent children. I only represent the department. And you're right, with a lot of counties, it's either the district attorney's office or the county attorney's office that represents the department. It really just depends on the resources that are available in each county.
Okay. So at what stage of the CPS process do you get involved?
It really depends on the case. In some instances, if an investigator or even a worker, a caseworker with family-based services, if they're working with a family and they have some questions about what the legal process is, if they wanted to, file for conservatorship, then they would call me and we would staff the case. For family-based services, if they have a family that they've been trying to work with and who needs more resources, or who, we're probably looking at a situation where the child needs to come into care because the parents aren't doing what they need to do in the family-based services case, then they would reach out to me and I could staff with them whether I think it's appropriate to ask the court to order them to participate in services, or whether we need to really ask for temporary managing conservatorship and bring that child into care. So it really varies by case and also by the different investigations and departments.
Okay. So when CPS is asking for a removal, I know they have to give you like a sworn affidavit that explains, their investigation and what they have, what they've learned from that investigation. The decision whether or not that moves forward to the judge, is that up to you? I mean, can you say to CPS you don't have enough before they give it to the judge? Or is that solely the judge's decision about whether or not they have enough basis for a removal?
So yeah, you're correct. The first step in the process is the investigator brings the affidavit to me. I review it. I then, if I believe that it supports requesting that we remove the child and request the court's permission to do that, then I present it to the court. If I don't believe that there's enough evidence or enough information to support that removal, then I'll ask the investigator, additional questions or ask them to continue with their investigation.
Okay. So explain the burden of proof for a CPS case and what burden of proof is for our volunteers.
Oh, goodness. So with CPS, there's different burdens of proof depending on the type of case that it is. In in a removal situation, it's the ordinary person of prudent caution standard, which is, it's the lowest burden of proof. So it's not preponderance of the evidence or clear and convincing or even beyond a reasonable doubt. The level of the burden of proof rises as we go along in the case. So once we get to the termination of parental rights, we have to get to the clear and convincing evidence of why and what particular ground that we're asking the court to terminate their rights on. If it's a case where we're just asking to be appointed as permanent managing conservator or asking that another family member be appointed as PMC, then that's more of a preponderance of the evidence. The only time we get to a beyond a reasonable doubt is when we're dealing with an ICWA case, and that's an Indian child welfare case. And if we're asking for termination of a parent's rights who has Native American history, then we have to get to that beyond a reasonable doubt. And as you can imagine, that's a pretty tough burden to overcome in those situations.
Talk a little bit more about the grounds for termination and the language that you guys use when you're in a termination trial. Explain to the volunteers what you're talking about and what those kinds of things are.
Okay, so there's a list of grounds that's in the Texas Family Code. And oftentimes you will hear the department refer to those grounds and the attorneys and the judge. You'll most likely, what the most common grounds we hear are D and E, which are those endangerment grounds. And those are usually what prompted the case to begin with. There's also what we call the N and O grounds, and those develop over time as the case progresses. The N and O grounds are service plan related. So the department prepares that service plan for the parents to complete their services so that they can be reunified with their child. If they don't complete those services, and also if the child has been in care for 6 months, 9 months, we can ask the court to terminate their rights under those grounds. One of them in particular requires that the parent not visit the child or stay in contact. And so I know it's confusing to those who don't speak the language, the CPS language, or who are new to the process when we rattle off those grounds, but there's a whole variety of grounds that are listed in the Family Code that I'm happy to provide a list to each of you so that you can see exactly what it is we're talking about. Oftentimes we just use shorthand because it is a very long code section.
Okay, great. So explain and describe the statutory hearings in a CPS case.
Oh goodness, so as you know, there are several. And I did provide a flow chart. I don't know if I can share the screen to where you can see what that looks like. Yeah, there's several hearings that we have to, so I can't, looks like I can't share that particular part of the screen. So let me.
Sorry.
So the very first hearing that we have, it's really an ex parte hearing. And that's where the investigator or the family-based services worker or the attorney, such as myself, goes to the court. We ask the judge to review our petition where we're asking the court to approve removal and appoint the department as temporary managing conservator in an order of protection. So once the judge signs that, we have 14 days before where we have to serve the parent. We give them notice of the hearing that's been set. And so we have a maximum of 14 days, which can be extended. And especially during this COVID crisis that we're having right now, we're having to reset some of our adversary hearings is what we call them. But oftentimes, sometimes we will get an order of protection on a Monday, and then we have court on Thursday. And so that's a very short time frame, but we have to set that hearing on the next available docket, which in Hill County, we meet every other week. And so we're going to court quite often with that. Once we have the adversary, at that adversary, we have to meet our burden of proof and show the court why the department believes it's in the child's best interest that would be appointed as the managing conservator. We then have 60 days from that point in time to have what we call a status hearing. And at that status hearing, that is where the conservatorship worker will present to the court the service plan that hopefully has been reviewed by the parents and signed by the parents. But at that service plan outlines the services that the department is asking the court to order the parents to complete. After that hearing, we then proceed to initial permanency hearing, which I believe is 90 days out. And at that permanency hearing, we're really starting to get a sense of, okay, where is this case going? Are we looking good for reunification? Are we looking at a monitored return? If the parents are doing well in their services, then that's what we're going to explore. If they're not doing well in their services, if they're not coming to court, if they're not coming to visits, if they're not participating in their services or going to counseling, or if they're continuing to drug test, maybe positive for illegal substances, then we have to start thinking about, okay, maybe it's time that we set this for trial because we're looking at possibly termination of parental rights. Then after that hearing, I believe it's another 90 to 100 days, 120 days, we have what's called the second permanency hearing. And that hearing is usually we're very close to trial date at that point in time. And we'll be resolving some issues, or maybe the parents have made a turnaround, and at that point in time, they might be asking for an extension, or they might be asking for a monitored return. A lot of different things can happen. There can be placement issues with the relatives of the child. And so we're addressing those. And of course, at each one of these hearings, Casa has an important role to play in that they're going to be providing updates to the court. But the department is tasked with, we have to have our cases resolved within 1 full year, or the case is just actually automatically dismissed from the docket unless it's been extended. And so we have to keep these cases moving. We want to get the parents involved. And so we have, these hearings every step of the way that are statutory, which means they're ordered and required. And so I think it's a really excellent way to keep the court apprised of what's going on. It also helps keep the parents on track with this is where they are in the case and what the expectations are, both from the department, also from the court.
Identify who the parties are to the suit and how does Casa fit into that?
Okay, so with every case, we have parents who are required parties. Whether or not they have custody of the child, they have to be given notice of the fact that we've filed suit. If there's any relatives who in the past, who we actually removed from that relative because maybe they had custody granted by another court, they're considered a party and they have to be notified of the proceedings. We also have attorneys ad litem for the children, and they are the attorneys that are appointed for the children. They're tasked with reporting to the court what the child wants. And so they have to be noticed of every proceeding. They participate in mediation. And with Casa plays the role of guardian ad litem. And Casa has they're basically the eyes and ears of the court. They are a required party. They have to go to the mediations. They need to be at the hearings. They need to be at the final hearing. They go to the permanency conferences, and they sign off on any agreements that are made, and they file reports with the court so that all parties are noticed of what Casa is recommending for the child and what to happen in the case. And so there could be more parties. There could be an attorney general. There could also be a Native American tribe that might intervene if there's a child who has Native American history. But for the most part, it's going to be the department. It's going to be the parents of the child, their attorneys, CASA, and the attorney ad litem for the child.
Great. So do you get a copy of the CASA court report before hearings?
Yes, I do.
What do you consider is the most important thing in that CASA court report? What are you looking for in that report?
There's always really good information in the CASA reports. I really look forward to reading them, not only for the recommendations. That's kind of, we always go to the recommendations to see what it is the volunteer is recommending happen at the upcoming hearing, and does it differ from what the department is recommending. And if I do see differences, then of course I have questions as to why that is. But what I really enjoy reading in the CASA report is just information about the child or children. How are they doing in school? Because we're going to see more information spelled out in the CASA report. They also may have some additional requests that the department may not request. And so I really enjoy kind of reading the reports to get a sense of who the child is. Because I believe the CASA, you're speaking more to teachers, you're speaking to doctors and others who can offer a unique perspective. So I enjoy reading them.
Do you ever have direct interactions with the CASA volunteer?
I do. It's not often, other than court. If there's a really unique special issue, I'll reach out to the CASA volunteer just to get their perspective on it. I may reach out to them for information on the final hearing, but I don't interact with them, as often as I would, with the department. And one reason why I want to do that is I really want the CASA volunteer to maintain that objectivity. And that's something I feel like if I'm not pushing my agenda, which I don't do, I don't feel like I have an agenda. I always try to be really transparent with the parents, and I think the department does as well. But I like for CASA to really kind of bring their own unique perspective to the court and not feel like they have to, oh, well, the prosecutor's calling me, I need to, I don't want to make them feel uncomfortable, but I do want them to be able to feel comfortable in court. And if they have any questions of me to help them feel more comfortable in court, I'm more than happy to talk with them about that.
So do you ever call a CASA volunteer as a witness? In Hill County, we don't usually do that unless it's at the adversary hearing or at the final hearing. Our judge in Hill County, usually will allow, both the department and also CASA to provide an update to the court unless there's a specific issue, and then we may be more formal. But usually we reserve kind of that formal testimony for the trial itself. And I know the CASA volunteer, as a guardian ad litem, they're given the opportunity to speak at the end of the trial, like when the attorneys make their closing statements. The judge calls on the CASA volunteer. What does he want to know from them in that closing?
I think their recommendations is always very helpful. Or if there's any information that the volunteer believes is relevant and the court needs to know about that maybe hasn't been touched upon. Sometimes when the department's giving an update, sometimes they may not include certain information. It's easy to do when you're you're on the stand, you might be a little nervous and you forget. And if Casa has additional information that they can provide, specifically with placement issues, sadly we don't, we sometimes don't have placement options for a child who may be at a shelter, and there may be some family members who might be interested, and if Casa has that information, I think that's always helpful to include that in the report. And of course also when you're in court and the judge is expressing some concern about potential placements. But I will say whenever Casa speaks, the court really perks up. And so the judge is very interested in what Casa has to say and what your recommendations could be, because you are boots on the ground. You're in the home, you're talking with that child, you're talking with the family. You don't have an interest in the case other than to do what's in the child's best interest. And so the court is going to be looking to Casa to provide that insight that he or she may not ordinarily get in the form of a report from the department or a parent's attorney.
Is your job different if there are criminal charges filed against the parents?
Yes and no. I mean, because I work for the department, I don't prosecute criminal cases, so it's nice that I don't have that kind of double duty, so to speak. So I don't have a conflict in that regard. As far as when there's criminal charges pending or if a parent's incarcerated, it is a little bit different because that parent can't engage in services, as much as a parent who's not incarcerated would. That parent has to rely on whatever services are available to them in a jail. And if they're being kind of shuffled around from jail to jail, then they're not going to have that opportunity to really get the resources. They do have some kind of correspondence and what we call a parenting packet that allows them to correspond with their caseworker, and they can keep in touch with their caseworker, but it does make it a little more difficult. It's difficult to reunify a child with a parent who's incarcerated and who may be incarcerated throughout the case. And so, yes and no, it makes a difference, but we still have our timeline. We still have to do the best that we can to reunify the child with the family who is available to accept that child when it's hopefully time for reunification.
Okay, so under what circumstances would CPS ask for that one-time extension of 6 months? When that 1 year runs out, they can ask for a 6-month extension. When would they do that?
Typically, we're more amenable to supporting an extension when you have either a child who needs additional treatment. For example, if we're in a case where, maybe it's a teen that came into care and we're joint managing conservators along with the parents, and that child needs to continue treatment for another 6 months or so to really get the help that he or she needs. Those are really good cases that we support for an extension. Other ones are where parents are doing the best that they can, and maybe they got a late start in services. Maybe treatment wasn't available or there wasn't a bed available for them to get the treatment that was recommended. But they're continuing to do the best they can. They're participating in counseling. They're staying in contact with their caseworker. They're going to all the visits that they possibly can. They're completing their parenting cases. So there's just maybe one service that they're just not going to be able to complete, or maybe they're living in sober living. And, we want them to get sober, and we want to reunify with the family to be reunified. Those are the types of cases that I think warrant more the extension versus those cases where maybe a parent's in jail and they think they're going to be paroled, in the summer, and they're asking for the case to be extended to allow them to parole out. Well, in situations like that, parole is not a guarantee, and usually the courts are a little more cautious about doing that because of the decisions that led to them being incarcerated in the first place. And so hopefully that answers your question.
Yeah. So what should a CASA volunteer never do? They need to know, you don't ever want to do this.
Oh, geez. I think the biggest things that I feel would be difficult for me if I were a CASA is you never want to lose your objectivity, and you never want to lose your cool. Objectivity because, as a lawyer, I can pursue a case, I can prosecute a case because, I'm not boots on the ground. I'm not meeting with that child all the time. I'm not getting emotionally vested in that child. Not to say I don't care about the children that are in our cases, but I can have some distance, some emotional distance from maybe the abuse or neglect that has happened. And I think with CASA, and what I've been really impressed with is the level of professionalism that the volunteers have in reviewing medical records that may have some really disturbing things, and being able to say, they're the professional as far as they want to do what's in the best interest of the child. And my dog's just barked at the garbage truck, sorry. Thank you, COVID. It's tough. It's tough when you see kids in hard places who are struggling. They want to go back home, or maybe they don't. And, the CASA is kind of their voice in court for the most part. And sometimes not their voice in court if they have to recommend something that the child necessarily doesn't want. It can be difficult to be objective. And so I would say, definitely try to maintain objectivity. The other part is, CASA also interacts not only with the parents, but the caregivers who get frustrated with the system. They get frustrated with parents, and they're also interacting with parents who sometimes are not always going to be nice to CASA volunteers who may be at a visit. It's, that parent is voicing their frustration, maybe not necessarily with CASA, but with whoever is there, because they don't understand why they need to be supervised. They may not understand and be frustrated by the fact that they're being redirected in a visit, or they may take that as criticism. And I've been very impressed in situations where a parent or someone else may be really hostile to a CASA volunteer, and they've maintained their cool. It's very hard to do that in situations where you might feel verbally attacked, or maybe even situations where it could, you've got people who are in crisis who, might have some, maybe intoxicated, we don't know, but those can be scary situations. And so I think doing the best that you can to always remain professional, so that when you do stand up in court and you testify on behalf of the child, we all know that you're doing this from a professional sense and not from an emotional standpoint.
Very good advice. All right. That's all the questions I have for you. Is there anything else you want to tell the CASA volunteers while you have a chance?
No, I'm just really happy that we have such wonderful volunteers, in Hill County, and it's been great to see everyone in court. I love the reports. They're very professionally done. They've got lots of great information, and it makes a difference because it helps develop, the case itself. Like, who are these children? What are the struggles that they're dealing with? And also just the fact that each Casa volunteer brings their own unique experience and qualifications, and life experience, and to have their perspective, I think is really valuable, not only to, the department, the court, but, also the parents and also the community, because I think, when Casa is talking with, the children's teachers and caregivers, they're probably going to get, some information that maybe those people wouldn't provide to the department, or they may be a little more hesitant to provide to the department than they would to a Casa. I also think it's really helpful to have Casa involved because, you're part of the community, and as part of the community, these are your children. And you may have some ideas for resources that, the department may not have. And, you have relationships with local churches and in schools, and each other, of course. And so we're just so grateful that you're here and that you're willing to serve. And, we want to keep inspiring you to help those kiddos out. And so if there's anything that I can do or the department can do to help you do the best that you can for those kiddos, we're here to help.
Great. Thank you so much, Jennifer. I appreciate your time. And this is a real honor to be able to have you to speak to our class because we don't normally have that. So I'm glad to have this saved, and I appreciate it so much. And we'll be seeing you in court.
All right. Well, I'll see you in court.
All right.
Have a good one.
Bye-bye.